being a corporation gives you some distinct advantages in terms of estate planning tools that are available to you as a business owner. They're not so applicable if you're part of a larger corporation where you have many shareholders, all who have smaller stakes in the company. But if you're the owner or one of a few owners of a closely held corporation, there's some specific tools that when you're thinking about succession planning and when you're thinking about your own estate plan that are available to you that are really effective. And we'll just talk about a couple of them in a second. So I read this kind of shocking statistic from the Canadian Family But the key part is that less than half of small businesses have a written formal succession plan. And for more than half of small businesses, I would suggest that that is a problem. People live in the moment, busy doing the day-to-day parts of their business that they need, and don't think about, not only what happens if, I get run over by a bus, but even if I'm sick for a prolonged period of time, what happens in my business? How do things get managed? How does the authority that I have as the owner, how does that get distributed, and how can I make sure that things are going to keep happening in my absence, whether that's short term or long term, let alone how do I structure that way so that it's efficient. So, some common issues with estate planning for business owners. The first one, and I think one that a lot of people are concerned about, but maybe don't know where to go, is leadership continuity, right? If you're a small business owner and you're looking at whether you're passing your business along to your children, your employees, retiring, planning to sell it, how does the business keep rolling smoothly when you as the owner, as the head of the business, start to step away or step away suddenly, right? The second one is tax implications. This is really getting into that estate planning piece that I was talking about before. But when you've grown your business up from nothing to this wonderful thing that in the eyes of the CRA is worth a lot of money, that comes with the exciting news that when you dispose of it, you may owe the CRA a bunch of that money. And the third one, which sort of comes into leadership continuity, is that people don't always think about what happens in the legal system when we pass away. And something that people don't necessarily think about is that if you are a small business owner and you pass away, you have a regular will, and that will goes through our probate registry, which depending on how busy they are, that's a long process. The typical estate takes up to, or more than 18 months to wrap up, and it could be ambiguous about who is supposed to be in control of your business. And if you think about, today, if I stepped away from my business and there was no leadership in place for 18 months, would there be a business 18 months later? As we got covered earlier, for probably more than half of small family-owned businesses, the answer would be no. So there's a bunch of kind of specialized tools in kind of estate planning, but also in sort of succession planning in general that are available to small business owners. This is by no means, a comprehensive review of all of them, but a couple of the more commonly used tools that we implement from a legal standpoint that people don't necessarily think about so often are a multiple will strategy and what we call an estate freeze. So going back to that whole probate thing, for anyone who's not familiar, if you're not a lawyer, why would you be? When you die, when you have a will, and your will goes through the probate registry, which is basically a fancy way of saying that the government rubber stamps your will and says, yes, it's an authentic will, the person that you've chosen to be your executor executor is in fact going to be your executor, and that everything looks good from their point of view, firstly, that's a time-consuming process. Your executor has to give notice to everyone listed in your will that they intend to apply as executor. Then they have to do the application, they have to submit it to the registry. Typical timelines for the registry to respond between getting your application and doing anything about it, depending on where you are in BC, are between 8 and 12 weeks. And from there, you actually are just at the start of the estate administration process. Now, if you're just talking about personal assets, that's not such a big deal, right? You're not going to be there, you don't really mind, right? But when you're talking about something that is sort of more of a living, breathing entity, your business, especially when there are people that you want to be taking it on, the fact that it could be hung up in this kind of probate situation for 18 months is a real problem. The other real problem is that despite the fact that we say we don't have estate taxes in BC, we do have what we call a probate fee, where essentially for everything in your estate that is going through this probate process, for the privilege of having that rubber stamp from the Crown, you owe them basically 1.4% of whatever that is. And again, if that's not a large amount of stuff, it doesn't really matter. But if you've successfully built up your business so that it's worth, $1 million, well, suddenly you're talking about thousands of dollars of probate fees. A multiple will strategy basically says, I'm going to have one will for stuff that needs to go through probate, and that's fine. It's just the way the system works. There are some things like if you you've paid off that beautiful house in Victoria, for that to be disposed of by your estate, because the Land Title Survey Authority won't just take your word for it with your will, that needs to go through probate. But if you are a small business owner with a closely held corporation, despite the fact that that might be worth more than your house, those shares don't need to be dealt with by your probated will. You can have a separate will that deals with things that don't need to go through the probate process, and that gives you two main advantages. The first one is you're saving that money, which is great. Even if it's not something that you're going to be around to enjoy, you've worked hard to build that up, and you want to pass it along to your spouse, or your children, your employees, whatever it is. The second one that people think about less, but I would argue is more important, is speed, right? So if you have a second will that governs your business, it doesn't need to go through probate. Your executor of that will can basically deal with that as quickly as they are physically able to, and the shares that you held in the business can go on to your children, spouse, employees, however you want to structure that, and that can happen very quickly, and then your business can continue to thrive. So that's a really important part of that, and why this is, for people that it's applicable to, a really great strategy. The other one that you may have heard of, because it's an increasingly common thing to do, and it does have some applications outside of business, but it's particularly useful for small businesses where your business is growing today and you're thinking ahead about the future, which is called an estate freeze. And to make a somewhat complicated situation a little bit less complicated, what you can do is you can utilize a share structure to take whatever the value of your business is today. Say you've built it up to the point where it's worth $1 million, but you're not done running your business. You've got another 5 or 10 great years in you. You have wonderful ideas for how much you're going to grow at that point, and then you want to pass it on to your children or to your employees or to whomever. What you can do is we can set up a share swap where the value of the business at that time is crystallized in terms of what's held in your name. So the stake you own value-wise, for capital gains, taxes, etc., will never grow beyond that $1 million. But you are able to retain, sole control of the company. You're not giving away, ownership of the company. You're not giving away, the ability to control what the company is doing. But you've created a different class of shares that you've given to your children and your employees, whomever those people are. And from that point on, any increased value in the company is going to grow in their hands, and you're only going to be limited to dealing with that $1 million of value that you currently have in your hand today. That has a lot of advantages. Firstly, I don't know if anyone's familiar or not, but at least for now, we have a lifetime capital gains exemption in Canada. As of last year, it was pegged at $1.25 million, and that's on a per person basis. So this can be a great thing to do if, for say, your company is worth around that now, and you have a spouse. You can institute an estate freeze, have the next $1.25 million of value of your company grow in your spouse's name. At the point where you sell it for $2.5 million, you're each eligible to claim that $1.25 million lifetime exemption and save yourself, a huge amount of capital gains tax. Likewise, you can do that with your children. It enables some sort of income splitting strategies if you are running a successful business and you have family members who are involved in the business. That can really work out well there as well. And obviously, this also will crystallize whatever your value in the company is in terms of your estate, so that even if it does pass through your single will, now the amount that you're going to be paying that probate fee on is only that crystallized value, not the amount that you've hived off to grow in the hands of your successors. So again, not the only possible strategy, but something that in the right situation can be incredibly helpful and